Criminal trial process by Brandon, John, and Myles. First one is opening statement by plaintiff or prosecutor. That is basically when they speak to the jury and give good first impressions, also to give the jury an overview of what happened with the case. Next one is the opening statement by the defense. Basically what that is, the defense tries to convince the jury the person is not guilty of the crime that they're being convicted with. Next one is direct examination of plaintiff or prosecutor. Before the witness should actually start speaking, he stands and asks the court, may I proceed? The purpose of direct examination is for the attorney to present evidence through the testimony of witnesses or through documents. Next one is cross-examination by the defense. That is when the purpose is to attack the other side's case, such as credibility, knowledge, or collection of witnesses. Next one is motion for dismissal. Motion for dismissal is a case can only be dismissed by the plaintiff. You can dismiss a party that you are talking to in court, or most of them. Next one is direct examination by defense. The questions by party to recall the witness testimony under oath in response to such questioning offers the defense lawyer an opportunity to establish the foundation of his arguments and to communicate the themes of his case to the jury. Next one is cross-examination by plaintiff or prosecutor. They basically help convict a person for a crime, so they basically say their case and how they feel and why the person is guilty of that crime. Next is closing statement by plaintiff or prosecutor. And that is when actually it's an opportunity to remind the jury about the key facts in the case. They try to persuade the jury after they've heard everything about the case. Next one is closing statement by defense. That is when they include statement involving why the defense is not guilty of the crime. They try to remind the jury that they are not guilty and show key evidence of what happened and why they weren't in trouble of that crime. Okay. And habitual argument. That is the part of a paper to attempt to disarm the arguments, to dismiss the power of the opponent. Second to last is jury's instruction. That's basically when the judge tells the jury not to talk outside the courtroom about the case, and he gives them instructions on how to give the verdict. And last is the verdict, which is when they try to say if a person is guilty or not.